We're going to have a committee hearing on this at a later date. It'll never be discussed. Nothing ever happens around here. I mean, they promise you stuff. They say we're going to take care of it, but it never happens, and I think it never will. The time to discuss the appropriate scope of the President's authority, this is Friedersdorf again, the time to discuss the appropriate scope of the President's authority is now, not in the aftermath of a catastrophic attack on the nation, as Holder suggests. The fact that he disagrees speaks volumes about Team Obama's reckless short-sightedness. This is another article from Wired. This is from today also. This is by Spencer Ackerman. The Obama administration calls it targeted killing. Steven Seagal would call it getting marked for death. It's the practice of singling out an individual linked to a terrorist group for killing, and it's played out hundreds of times in the 9/11 era, including more recently against U.S. citizens like al-Qaeda's YouTube preacher Anwar al-Awlaki. The Obama team has said next to nothing about how it works or what laws restrict it until Monday. Attorney General Eric Holder explained that the administration's reasoning for killing American citizens overseas, and only overseas, with drone strikes and other means during a Monday speech at Northwestern University. Holder claimed that the government can kill a U.S. citizen who is a senior operational leader of al-Qaeda or associated forces, provided the government unilaterally determines that the citizen poses an imminent threat of violent attack. Once again, a little bit of a problem on the imminent doctrine is that imminent doesn't have to mean immediate. He can't be captured, and the law of war principles, like the use of proportional force and the minimization of collateral damage. The reason why some of this is important, even though he's talking about overseas now, not what we're trying to talk about here, is that since we haven't been given sort of the parameters for how they will kill Americans in America, we can only assume that they'll work with the parameters they have overseas. The whole idea that an imminent threat's not immediate is problematic no matter where that doctrine is used. The idea that the law of war principles, I think proportional force is a good idea, as far as, trying to restrain how much force we use. But there's other things within the law of war that we need to be concerned about, that things that happen in war aren't quite the same kind of standard that we would have in the United States. Ackerman goes on and he says, this is an indicator of our times. This is actually Holder. This is an indicator of our times, not a departure from our laws and our values. The debate over killing al-Awlaki, whom Holder barely discussed, began long before a Hellfire missile fired from a drone killed him and fellow propagandist Samir Khan in September. Al-Awlaki's father sued the Obama administration in 2010 to compel it to reveal its legal rationale for the long telegraphed strike. The administration refused with a judge's support. For months after al-Awlaki's killing, the government never disclosed any evidence supporting its decision that al-Awlaki posed an imminent danger to Americans, beyond his rhetoric of incitement. But during the February sentencing of the Unabomber, or the underwear bomber, the government put forward a court ruling, or a court filing, claiming that al-Awlaki worked intimately with convicted would-be Umar Farouk Abdullah Muttalab, who was the underwear bomber, to blow up Northwest Airlines. Holder referred to that connection in his speech. Several legal scholars have wondered why the U.S. didn't have to provide al-Awlaki with due process of law before killing him, as stipulated under the Fifth Amendment. Holder contended that the U.S. actually did, even if no judge ever heard the case. This is sort of an interesting point. And I'm not really making an opinion on whether or not the Fifth Amendment applies to al-Awlaki overseas. I think a lot of that's complicated and not necessarily certain whether you can apply the Constitution to people outside the United States. or whether an entity within the United States should obey the Constitution on people outside the United States. The bottom line is, in war, you're not going to really get due process, and you're not going to get Miranda rights if you're fighting in battle. It's a little bit more debatable when you're not. The point is, though, that they're saying they're applying the Fifth Amendment sort of in private to Milwaukee. The question is if this is the standard that's going to be used in the United States, it's not going to be the actual use of the Fifth Amendment, which means a court and a jury. It's going to be the pretend use that's done behind closed doors. I'm not so sure you can have the Fifth Amendment, that doesn't involve a courtroom. I don't know. I just don't understand. Grand jury indictment, due process, not to be deprived of life and liberty. I don't know how it happens in private, but that's the way they're administering the Fifth Amendment in private, and they're using their discretion as to when to administer the Fifth Amendment. But I just don't know how that's going to work. I also don't think that's appropriate for U.S. citizens. So really, other than the president asking and answering a question as to whether non-combatants will be killed in America, he needs to ask whether he's going to, before he kills them, is he going to use the Fifth Amendment in private in the Oval Office, or is the Fifth Amendment going to be public? If it's public, I don't know how you kill somebody. If you really are going to get some kind of due process, you'd have to get tried in a court. I'm not sure how this would go forward. This is an additional quote from Holder from the same speech. The Constitution's guarantee of due process is ironclad, and it is essential. But, as a recent court decision makes clear, it does not require judicial approval before the president may use force abroad against a senior operational leader of a foreign terrorist organization with which the United States is at war, even if that individual happens to be a U.S. citizen. Well, that's kind of confusing. I mean, if that's going to be the standard here, I'd be quite concerned. The standard over there, I think there's arguments on both sides of, but the standard over here, I just can't imagine that this is the standard we're going to use. Because basically he's saying the Constitution applies unless we think it doesn't apply, and they've decided that it doesn't apply. But then he says, as long as we're at war, well, who are we at war with? You have to decide. We're at war basically with anybody who doesn't like us around the world, and I'm not sure if there's ever an end to that. I think there are problems overseas, but particularly the problem is, and I think the problem at hand that we're trying to get to the root of is that, is this the standard? If you're using this standard overseas, are you going to use the standard here that basically the Fifth Amendment applies when we think it applies and it doesn't apply when we don't think it applies? Now this is Ackerman at this point from Wired again. Holder did not explain why Milwaukee's 16-year-old son, whom a missile strike killed 2 weeks after his death, was a lawful target. Holder did not explain how a missile strike represents due process or what the standards for due process the government must meet when killing a U.S. citizen abroad. Holder did not explain why the government can only target U.S. citizens suspected of terrorism for death overseas and not necessarily domestically. The thing to be, like I say, a lot of these things overseas, you can debate and try to decide whether or not, this is a war zone or not a war zone, but they obviously don't apply in the United States. The most troubling thing about Milwaukee, the 16-year-old son of Milwaukee, is the president's spokesman's response to this. The flippant nature of it and the, I think, irresponsible, nature for him to have said, well, he should have chosen more responsible parents. I think if that's the standard we're going to have for killing Americans on American soil, that we're going to kill people who, don't have responsible parents, we've set the bar pretty low for our killing program. I think Milwaukee was killed. I don't know. I've not seen the the classified information. I think the son was killed probably when they either targeted someone else or they did what they're calling these signature strikes, where they don't know who they're killing necessarily. They just think they're bad people because they came from a meeting of other bad people. The decision to kill an American, Holder said, is among the gravest that American government leaders can face. Targeted killing is not assassination, he argues, because assassinations are unlawful killings. Among the few external limitations of the government's war power that Holder mentioned were the approval of local government where the strikes occur, which must have pleased reluctant, unsteady U.S. allies in Pakistan and Yemen. So I guess he's saying that, interesting thing, and probably Pakistan has approved of most of the drone killings, but Pakistan wants to kibitz and say, oh, no, we haven't. They're doing it against our will, but my guess is they've been told. Some members of Congress don't consider this to be a sufficient safeguard. The government should explain exactly how much evidence the president needs in order to decide that a particular American is part of a terrorist group, says Senator Ron Wyden, an Oregon Democrat who sits on the Senate's Intelligence Committee. This is a further quote from Senator Wyden. It's also unclear to me whether the individual Americans must be given the opportunity to surrender before lethal force is used against them. And I'm particularly concerned that the geographic boundaries of this authority have not been clearly laid out. You know, the point on the geographic boundaries is a pretty important point, because, see, this is one of the concerning things about what they maintain. They say there are no geographic limitations. They say they get the authority for war everywhere around the world as well as war here, because they say there are no geographic limitations to the use of authorization of force when we went to war in Afghanistan. I think people who voted for that, and I would have voted to go to war in Afghanistan, but people who voted for that, I think, thought we were going to Afghanistan to fight the people who got us on 9/11. I don't think they thought when they voted for that resolution that it meant that we could have war in the United States under that resolution, and that the standard would be one of the laws of war or one of martial law within the United States. I don't think anybody voting on it had that conclusion, but that's the real problem, is that people are saying, including the administration, is saying no geographic limitations, and essentially there's no temporal limitations. So we have a perpetual war without any geographic limitations, which now they want to apply war principles to killing in the United States. This is Ackerman going on, and he says, based on what I've heard so far, I can't tell whether, this is still Senator Wyden. Based on what I've heard so far, I can't tell whether or not the Justice Department's legal arguments would allow the president to order intelligence agencies to kill an American inside the United States. So he's unclear about it, and he's seen a lot more information than I have, because he's on the Intelligence Committee and sees secure and classified information, and he's unsure of it. And so that makes me think that nobody in the Senate or the Congress really knows whether or not they're asserting whether they can kill Americans on American soil. Mary Ellen O'Connell, the Vice President of the American Society of International Law, found Holder's legal rationale flimsy. This is her quote. First, Holder restates the renamed Global War on Terror, which Obama himself condemned. Then he tries the UN Charter Article 51, but does not include the whole article. It says member states of the UN have an inherent right of self-defense if an armed attack occurs. Article 51 does not provide a legal green light for targeted killing. O'Connell said in an email. Finally, he adds, the argument that the U.S. may use force against states that are unable or unwilling to attack. This argument has no basis in international law. It simply does not exist. So regardless of how carefully you target under the law of armed conflict, there is no right in the first instance to target at all. Mr. President, without yielding the floor, I'd like to entertain a question from the senator from Utah.
Senator Paul, so you recently sent a letter. Go on for a little. Okay. Senator Paul recently sent a letter requesting some information from the Obama administration with regard to these issues relating to drone strikes. It is significant that on March 4th, 2013, just a couple of days ago, Senator Paul received back a letter from the administration that reads as follows. It says, "Dear Senator Paul," this is signed by Attorney General Eric Holder, Jr. On February 20th, 2013, you wrote to John Brennan requesting additional information concerning the administration's views about whether the President has the power to authorize lethal force, such as a drone strike, against a U.S. citizen on U.S. soil and without a trial. As members of this administration have previously indicated, the U.S. government has not carried out drone strikes in the United States and has no intention of doing so. As a policy matter, moreover, we reject the use of military force where well-established law enforcement authorities in this country provide the best means for incapacitating a terrorist threat. We have a long history of using the criminal justice system to incapacitate individuals located in our country who pose a threat to the United States and its interests abroad. Hundreds of individuals have been arrested and convicted of terrorism-related offenses in our federal courts. The question you have posed is therefore entirely hypothetical, unlikely to occur, and one we hope no president will ever have to confront. It is possible, I suppose, to imagine an extraordinary circumstance in which it would be necessary and appropriate under the Constitution and applicable laws of the United States for the President to authorize the military to use lethal force within the territory of the United States. For example, the President could conceivably have no choice but to authorize the military to use such force, if necessary, to protect the homeland in the circumstances of a catastrophic attack, like the ones suffered on December 7th, 1941 and September 11th, 2001. Were such an emergency to arise, I would examine the particular facts and circumstances before advising the President on the scope of his authority. Sincerely, Eric H. Holder, Jr., Attorney General. So it is good to have this letter as a response to Senator Paul's inquiry, and I believe that the inquiry Senator Paul raised is a legitimate one. It is also essential that we have some clarity with regard to the administration's position on this type of an attack. It is important for us to remember that every time government acts, it does so at the expense of the liberty of individual Americans. This doesn't mean that government action is bad. This simply means that government action always has to be weighed, it has to be counterbalanced against the impact that it has on the citizenry. It's very important that we approach these things delicately. Nowhere is this balancing act more necessary than where we have circumstances in which government action threatens not just the liberty, but also the property, or most importantly, the life of an individual American. Where life is threatened, the concerns of the Constitution are at their highest. Where life is threatened as a result of government action, government owes it to the citizens to undertake all of its activities with utmost caution. It owes it to its citizens never to deprive human beings of their lives, particularly American citizens, and unless it has done so through operation of law, with what we call due process of law. It is on this concept, due process of law, that the 5th and 14th Amendments of our Constitution focus so intently. Due process of law is a familiar phrase to many Americans. We've heard this phrase over and over and over again. We understand on some level what it means, but I'd like to talk for a few minutes in response to Senator Paul's question about the fact that in order to have due process of law, you have to have a familiar legal standard, or at least a legal standard. You have to have a law that is capable of being applied in a way that American citizens can understand. They can read the law, they can review it, they can understand what the law requires of them. They can understand what it is that the law demands and what it is that the law authorizes the government to do. You see, because in the absence of such a law that can be applied, a law that can be understood in advance of its application, you run a very real risk of arbitrary and capricious government action, where government action is arbitrary and capricious and where it threatens to undermine life, liberty, or property, but especially life. You have the greatest level of concern, where the greatest level of detail must be examined with regard to what the government wants to do. So in this circumstance, where the question relates to whether, under what circumstances, to what extent, the government may take an American life, the government may snuff out the life of an individual American citizen, the government has an obligation to see to it and to assure its citizens that it won't ever undertake such an action without due process of law. And to have due process of law, you've got to have a discernible legal standard. A discernible legal standard is not entirely evident on the face of this letter. It's understandable. This is just a letter, a brief response to Senator Paul's inquiry. It is, however, a little bit troubling that Attorney General Eric Holder doesn't do more to assure Senator Paul in this response to his letter that these kinds of actions wouldn't be necessary to undertake on American soil, that these kinds of actions would be fraught with constitutional problems when undertaken on American soil. It's difficult to understand why the Attorney General wouldn't just say, we won't do this. This would be fraught with constitutional problems. This is not something we would do. Also troubling is the related point that the Attorney General has apparently relied on some legal analysis provided by the chief advisory body within the U.S. Department of Justice. The U.S. Department of Justice is something that one might loosely describe as the largest law firm in the United States. It is the law firm of the federal government. And within any law firm, you've got lawyers who do different things. You've got lawyers who specialize primarily in litigation. You've got lawyers who specialize primarily in drafting agreements or in giving advice to people. The Office of Legal Counsel within the U.S. Department of Justice is the chief advisory office within DOJ. It was the Office of Legal Counsel that drafted one or more memos outlining the circumstances in which the Obama administration might consider undertaking actions involving lethal force against American citizens. Sadly, most of us in the United States Senate have been unable to review those. The American people generally have been unable to review them. But it is particularly frustrating that those of us who are members of the Senate Judiciary Committee and therefore have an oversight responsibility over the U.S. Department of Justice have not been fortunate enough to review the memorandum upon which the Obama administration has apparently relied in undertaking this legal analysis. I had the opportunity to question, and did question this morning, Attorney General Eric Holder with regard to these memoranda, explaining to him the great need that we have to be able to review these memoranda, particularly as members of the Senate Judiciary Committee. I explained to him that this is part of our oversight responsibility, that this is our duty, it is our right to see such documents, and that it's very frustrating that we have not been allowed to see such documents. I added to that my concern that what we do have is a different document, not the Office of Legal Counsel memoranda, but instead something that is captioned simply as the Department of Justice white paper. I always thought that was an interesting phrase, white paper. You know, I don't know why they feel the need to call it that, why they don't just call it a paper. Normally we don't have legal analysis or other important documents that are written on green paper or orange paper or any other color of paper, but nonetheless they call it a white paper. This paper was leaked by the Obama administration to the news media. And this particular paper purported to contain some analysis, perhaps in summary form, the same type of analysis of what was used in the still secret Department of Justice Office of Legal Counsel memorandum. There were a couple of things that I found very disturbing about the contents of the white paper. First, the white paper focused on the fact that the U.S. government may use lethal force to kill an American citizen only where there is an imminent threat of some sort, where the other conditions outlined in the memorandum are satisfied, there still has to be an imminent threat of some sort, an imminent threat that the use of lethal force by the government on the U.S. citizen in question is designed to confront. Well, that is a somewhat familiar legal term. It's used in other contexts to identify a circumstance in which one thing has to occur in order to prevent something else even worse from happening. An individual, for example, when confronted with an imminent threat to his or her own life, is entitled to use lethal force in defending him or herself in order to avoid that attack, in order to avoid death. But it does have to be an imminent threat. There are other examples. When a person argues that a certain action was undertaken under duress, there does have to be some degree of imminence. And it is appropriate in this circumstance, when we're talking about authorizing the government, the federal government of the United States of America, to use lethal force on an American citizen, there ought to be some sort of imminent threat to American national security that necessitates and fully justifies that action. But the strange thing about the white paper, this white paper that was leaked by the Obama administration to the news media, is that it redefined imminence. It redefined it completely. It defined it to be something else, something that bears no resemblance to what you or I would call an imminent threat. And it seemed to suggest that an imminent threat may occur even when there is nothing that is about to occur on an immediate basis that would involve a loss of American life or an attack on an American compound or installation or any kind of a loss or a deprivation to American national security. So this is a problem. You see, because as we discussed just a few minutes ago, in order to have due process of law, you have to have law operating. And you have to have law operating as something other than a tool to justify arbitrary and capricious behavior by government. You have to have a discernible, judicially manageable legal standard, even if it's something that's never going to go through court. It needs to be a legal standard that means something, that has teeth to it, that doesn't just say government officials may undertake action X, Y, or Z if the government official in question feels moved upon to take such action. There needs to be something that has the capacity to restrain government action, and it needs to be on the basis of and by operation of generally applicable standards, generally applicable rules of law. That's what we mean when we say due process. And again, due process and the restrictions that accompany it are at their highest when government wants to take an action that is designed to or could lead to the ending of a human life. The sanctity of human life requires nothing less than that. Now, there was another part of the memo that was also a little bit disturbing. The other part of the memo suggested that it would of course be necessary in order to carry out an action involving lethal force against an American citizen, that efforts to capture that individual would somehow prove to be futile, that those efforts wouldn't work. But there again, the definition supplied by the white paper suggested something else. The language of the white paper suggested almost that the government official in question, in charge of this decision to end an American citizen's life, could be made somewhat arbitrarily, somewhat capriciously. This is a problem. You don't want somebody just sitting there one day having the authority to say, so-and-so is a troublemaker. So-and-so shouldn't be there. so-and-so has been involved in some very bad actors. So-and-so may in fact be a bad individual, may in fact be associated with people who want to harm the interests of the United States, or may even have been involved in planning of attacks on the United States. You don't want the government official in question to be able to end that American citizen's life just on the basis of flimsy analysis, on a toothless legal standard. You want the American people to continue to be able to live under the rule of law, and with an understanding that actions of government, particularly those actions that are designed to bring an end to a human being's life, won't be undertaken lightly. You see, that's what it means to live in a society that operates under the rule of law as opposed to the rule of individual human beings, is that we have standards, we reduce those standards to writing, those standards that are rules that are generally accepted and generally applicable, that govern the conduct of individuals in society, both the governors and the governed, will themselves determine the behavior of those involved in our society. And so our law of laws, our rule of rules, our most fundamental law is the U.S. Constitution, this 225-year-old document that I happen to believe was written by the hands of wise men raised up by their Creator to that very purpose. Wise men who understood human nature, wise men who understood that whenever you put an individual in charge of a lot of other individuals, there are risks that are inherent in human nature, risks that can be managed if you put certain checks and balances in place, checks and balances that will ensure that no one person, no one group of people will become so powerful as to become a law unto themselves. That, you see, is what this document, our Constitution, the Constitution of the United States, was designed to ensure. That we as Americans would live free. We would live free because our laws would govern us, not the whims, the caprice of individuals. Now, I do have here another letter that I'd like to share. This is a letter that was sent to my friend Senator Paul from Mr. John Brennan, currently serving as Assistant to the President for Homeland Security and Counterterrorism. This letter is dated from just earlier this week. In fact, it's dated March 5th, 2013. Here's what it says. Dear Senator Paul, thank you for your February 20th, 2013 letter regarding the power to authorize lethal force, such as a drone strike, against a U.S. citizen on U.S. soil and without trial. The Department of Justice will address your legal question regarding the President's authorities under separate power. I can, however, state unequivocally that the agency I've been nominated to lead, the CIA, does not conduct lethal operations inside the United States, nor does it have any authority to do so. Thus, if I am fortunate enough to be confirmed as CIA Director, I would have no power to authorize such operations. In addition, I've asked the CIA to respond to your letters of January 25th and February 12th, 2013, which raise a number of important questions regarding issues pertaining to the advancement of America's strategic priorities around the globe. Sincerely, John O'Brennan. So this is helpful. This is a helpful indication from a government official who's been nominated to head the Central Intelligence Agency, who acknowledged that if he is confirmed to this position, he would have no authority as director of the CIA to order lethal drone strikes within the United States, and that's helpful. It is still significant, I think, that we be allowed to ask from time to time what the CIA might do with regard to other persons including U.S. citizens outside the United States, under what circumstances a lethal drone strike or a different type of lethal force might be appropriate when directed toward an American citizen outside the United States. Notice one phrase that he uses in this letter when he says, such as a drone strike against a U.S. citizen on U.S. soil and without a trial. Whenever we're talking about any person within our jurisdiction, whenever we're talking about an American citizen, regardless of where that American citizen might be found, it seems to me that we do owe that person certain responsibilities. We owe that person a duty of following the law, of following our most fundamental law, the U.S. Constitution, and following other statutory authorities that we have in place specifically to protect the rights and the interest, the life and the liberty and the property of the American people. We're told that those things cannot be taken by the government without due process of law. Now, normally, when we take away someone's life or their liberty or their property, normally we entitle that person to a trial. And this is where our constitutional protections overlap a little bit and they complement each other. So we have in the Fifth Amendment this protection that says that no person shall be deprived of life, liberty, or property without due process of law. And there again, that entails at a bare minimum the operation of these generally applicable laws that actually have some standards to them. It typically also involves, quite necessarily, an opportunity on the part of the person being acted upon by government to have a trial. So we have elsewhere in the Constitution other protections that guarantee this. We have protections indicating that if a person is charged with a crime by our government under the Sixth Amendment, they have a right to a jury trial. And they have a right to counsel in connection with that trial. They have a right even to counsel paid for by the government if they can't afford an attorney in connection with that. The Seventh Amendment likewise protects the right to a trial in the context of civil disputes. So these and other protections overlap to guarantee that Americans will have due process. And frequently what due process entails, among other things, is the provision of a jury trial. You see, juries do perform an important function. Juries are there to help protect our rights. When we have a jury of our peers deciding critical questions with regard to our interests in life, in liberty, in property, we see to it that a panel of laypersons, a panel of non-government officials, a panel of citizens who have sworn an oath to do justice will do precisely that. And they will not shrink from the obligation to enforce the competition, to enforce the demands of the Constitution. They will not shrink to enforce the demands of the law. They will not shrink from their duties, and they will not see themselves as part of a government establishment. You see, this is how our Constitution protects us. It insulates us from the government because we are the people, and we the people control the government. We the people have the right to a jury trial, and when we actually get a jury trial, we're able to see our rights protected. And so, Senator Paul, in response to your question, I do think that there are some problems that we confront as a society. I think that the security of the United States is, of course, of paramount importance. We need to protect American national security. We need to protect Americans. And as we do so, we also need to protect the inalienable rights of individual Americans to the due process guarantees that are hundreds of years old, that extend at least as far back as the drafting and ratification of our Constitution, and are, of course, much older than that. They are centuries, indeed, they are millennia old. We must continue to honor them.
Mr. President, I'd like to thank the senator from Utah for his expert constitutional analysis, and I rely on his advice and analysis of legislation, and want to thank him very much for being part of this debate. We are in contact with the White House, and we've told the White House that we will allow debate on Brennan as soon as they'll give a clarification of what their opinion is on drone strikes in America. I think really that after Holder's cross-examination, that his opinion may not be too far off from what we're asking for, but we want it clarified and in writing because we think this is an important battle for the American public and an important battle for the Constitution. And so if the President or the Attorney General will promise to give us something, even give us something by morning, we're more than willing to go ahead with the vote in the morning with that information. And at this time, Mr. President, without yielding the field, I'd like to entertain a question from the Senator from Wyoming.
Mr. President.
Senator from Wyoming.
Thank you, Mr. President. I come to the floor of the Senate in great admiration of the Senator from Kentucky and what he's doing to try to get information. All we're asked to do is give advice and consent to the President on this very important nominee to be the head of the Central Intelligence Agency, the key to Central Intelligence in this nation. So I come to the floor this evening to thank my colleague from Kentucky for the leadership that he has continued to show by asking questions which are not just questions of his, they're questions of the American people. I was traveling around the state of Wyoming last week talking to folks, went to about 13 different counties in our state of 23 counties, many questions being asked about drones and not just their accuracy, but the intent and what this administration's policy is related to drones and how they can be used. People in my home state of Wyoming are concerned about drones being used in the United States, not just specifically for attacks against American citizens, but also the concept in observation, in surveillance. What about our rights as citizens to privacy? So those are the questions that come up as I travel around the state. I had a telephone town hall meeting the other evening with many people from all around Wyoming on the line. They admire the questioning from the senator from Kentucky. They have concerns about what is Big Brother watching, what is happening, and what role is government in observing and surveillance and looking into the lives of the American people. But it wasn't really until Senator Paul asked the question of would there be strikes on American citizens in America that I think things really became very focused at home and all around the country. And then we got more emails, more concerns, because these are questions, and the specific question that Senator Paul is asking is a question that's on the minds of all Americans, and I believe Senator Paul deserves an answer. The American people deserve an answer. So it's not just Senator Paul that deserves an answer, it's an answer to all of the people of this country, but I appreciate Senator Paul's leadership in asking the specific question. Now, the Intelligence Committee, the Select Committee on Intelligence, met. They had hearings, they had debates, discussions, deliberations, and actually they voted. And that's why we are here on the floor tonight to ask finally from the White House and from the nominee what the specific position and policy of this administration happens to be on drones. I know we have a unanimous consent request from Senator Paul, and I'm going to, in a second, ask him to explain and maybe reiterate his unanimous consent request, explain the resolution that he would like to vote on. I think the senator deserves a vote. We want to make sure the public understands what we are discussing here, and that's why I appreciate the leadership of Senator Lee, who has come here as a constitutional scholar to address some of these same concerns. Because I think before many senators are able to make the final decision of how to vote, how to give advice and consent to the White House, that we need more information. We need to hear from the White House. We need to hear from the administration, because the people all around the country want those same questions answered. So we do have a situation where the senator from Kentucky said he is willing to have a vote. He is willing to allow a vote on this nominee on the floor of the United States Senate as soon as his question is answered. And he would be happy to proceed with that vote as early as tomorrow morning. The American people deserve better than they're getting right now from this administration in so many ways, this just being one. And that is why I think all of us try to go home every weekend to see what's on the minds of folks in our home states and our home communities. But this is clearly what I have been hearing about traveling around Wyoming, a state of vast open spaces, a state of great majesty and beauty, but a state where people are concerned with their own privacy, with overhead surveillance, and of course not just their own personal privacy, but their security. And what are the rights and responsibilities of a national government when now technology exists, as we've seen with drones. And I had the privilege of visiting our soldiers overseas in Afghanistan with a number of senators in January. We have seen up close through detailed video the capabilities of drones, capabilities that just weren't there that many years ago. Questions like this would have never arisen a number of years ago because the technology wasn't there. But now the technology is there. And with that given technology, that raises new questions. And that's why I think so many Americans are appreciative of the work by Senator Paul to specifically ask questions that have never been asked before because the technology wasn't there before. But now we have the technology, we have the know-how, and the question continues to be asked. So I would just ask my friend and colleague from Kentucky if he could explain, perhaps his unanimous consent, what vote he's asking for, why it is so important, and what it means to all of us as free citizens in this great nation. Thank you.
Mr. President, I would like to thank the Senator from Wyoming for coming to the floor and helping to advance this debate. One of the points you made towards the end, or that was made towards the end, is about our soldiers and that you visited and seen the capacity of the drones. The one thing that shouldn't be lost in this is that we're not here arguing against the use of drones, particularly in defense of our military. When people are shooting at our soldiers, I want the best equipment we have in the world to defend them and to win our battles. That's something that we should all want. But I think our American soldiers would be disappointed in us here at home if they felt like, which I think many of them do who I've spoken to, that they're fighting there for our Bill of Rights. They're fighting for our Constitution. They're fighting for our conception of freedom. And in doing so, I think they would be disappointed if they felt like the drones that were being used against the enemy in the mountains of Afghanistan and Pakistan were going to be used against Americans in America without any kind of due process, because the whole idea of the Constitution, that's what they're fighting for. It's what the President, has pledged to uphold and preserve, and so it's such an important battle. The unanimous consent that we've put forward, which had hoped they would let us vote on in the morning also, but they've disagreed with, basically says that the use of drones to execute or target American citizens on American soil who pose no imminent threat clearly violates the constitutional due process of citizens, the due process rights of citizens. And the point we're trying to get at, which I think the administration, really it ought to be an easy question, we're not talking about someone attacking the Twin Towers. We're in agreement that the military can repulse attacks by American citizens in planes. Some of the hijackers, I think some of them, I don't know if any of them were citizens or not, but some of them were some of them were citizens, I think. But anyway, the point is that no matter who you are, if you're attacking the United States, you can be repelled, and that lethal force can be used. The point is, though, that we're concerned that some of the drone strikes overseas are done to people who are not involved in combat at the time, and that's another question. But here at home, I think really we don't want to have a standard where someone who we think might be a terrorist or we think might be engaged in something who's in a restaurant eating dinner would be killed. And I think that we want more protections for Americans. We want, if you're accused of a crime, to have the ability to defend yourself in a court of law. But I would, without relinquishing the floor, be happy to entertain any other questions.
Mr. President. Well, I think, Mr. President, I just come in and ask my colleague about if this is something he may have heard about at home as well, because this is something clearly on the minds of the people of Wyoming. And And of course, just like Kentucky, and I will tell you, when I was overseas in Afghanistan, I ran in not just to soldiers from Wyoming and met 8 of them in 4 different locations that I went to throughout Afghanistan. I met soldiers from Kentucky in each of those locations. So we were both from states with a significant commitment to our military, as people over the centuries have continued to fight and defend our freedoms. But today in Afghanistan, we have soldiers from my home state and your home state doing what they do to keep us free, defending the Bill of Rights, defending the Constitution. And when we talk about the Bill of Rights, I mean, let's think about what Ronald Reagan said. The Bill of Rights wasn't established. It was not established to protect the government from the people. It was established to protect the people from the government. Search and seizure, freedom of press, freedom of speech, freedom of religion, our Second Amendment rights to own and bear arms. Those are the constitutional rights, individual rights, that people are fighting for every day in Afghanistan. And they want to know, when they get home, what sort of freedoms are there going to be in this country? Where does the role of liberty and freedom in our society? And that's why there is no better time, I would say, Mr. President, than this evening, before voting on the nominee to be the director of the Central Intelligence Agency, the head of the CIA for the country. I mean, what better time than to have this debate than during that nomination process about where is that line between freedoms of individual citizens and the rights of a government, which now has a technology which hasn't really been there up until most recently. And so I would ask my friend and colleague, one, congratulate him and thank him for remarkable leadership, and I hear that all around my home state, and I know you hear it at home as well. You hear it all around the country. But say, is this a concern on the minds of people, or is there a reason that we are here to bring this out, not just because a couple of senators are on the floor debating it, but this is a crucial issue for this nation?
Mr. President, one of the things I hear at home that similar to what the Senator from Wyoming is talking about is that we hear people worried about the erosion of their rights. They worry about statements from the President when the President says that he intends to protect the Constitution, and except for maybe when it's infeasible or when it's inconvenient. And I think that worries people. One of the other things about drones, which is not particularly related to this necessarily strike, but I know in Wyoming, I'll bet you they have the same concerns, is our farmers aren't too happy about the government flying drones over their property. And that's something, we had an interesting vote on that last year. We had a vote on whether or not the EPA could continue these without explaining to us. Once again, it was sort of similar to this fight in the sense that we wanted to stop the drone flights over farms, and it was a pretty simple request, an easy request, until we got the government to explain what kind of criteria, what kind of rules they were using for flying over farms. And we got 56 senators to vote to ban these drone flights until we got more information, but it's like a lot of other things in the Senate. It took 60 votes, so we didn't actually quite win, even though we had a majority. With regard to what we're trying to accomplish through this is the main thing we'd like is a public acknowledgement from the President or from the Attorney General saying that their policy is not to kill non-combatants in America. Many of the drone strikes overseas have been non-combatants. At least at the time they're killed, they're not involved in combat. I don't think that it's too much to ask the President to clarify that what he means is the U.S. can repel invasion, the U.S. can repel attacks, whether they're American citizens or not. We don't have a dispute with that. Our concern is that when you look at the drone program overseas, that a lot of people are sitting around eating, walking, sleeping in their house, that's not sort of a program I can imagine using in the United States. I can't imagine that we're going to have drone strikes on people while they're asleep in their home, or whether they're out eating in a cafe or eating in a restaurant. I can't imagine that that's the standard we're going to use. Maybe it's just a misunderstanding. Maybe the President could clear this up. When Attorney General Holder was there this morning, the senator from Texas asked him this question, and under pointed questioning, it seemed as if he was backing towards an answer that might be acceptable. He said it wasn't appropriate, but really what we're looking for from the lead legal officer of the president, from the president, is something a little more precise than "I don't intend to," or a little more precise than it's not appropriate. We would like them to say that they don't have a legal authority to kill Americans on American soil. We just don't believe they do. Targeted drone strikes in America, I don't think that they have the legal authority nor the constitutional prerogative to do this, and they just need to admit to that. But it's been like pulling teeth getting information or getting them to acknowledge anything, and that's what our goal is. Our goal is to try to get the president to acknowledge something publicly. More so than any kind of legislation. We do have some legislation we're interested in. We're not demanding that it pass in order to let this nomination go forward. What we're asking for is that we'll let them have a vote anytime they want if they will at least give us a little more of a clear understanding that they're going to obey the law. It took a month and a half for us to get the response from them that the CIA doesn't operate in the United States. That just is the law. It's been the law since 1947. You wouldn't think it's that hard to get them to acknowledge they're going to obey the law. The Posse Comitatus law has been there since the 1860s. It says the military doesn't operate in the United States either. How hard is it for the administration to say, we're going to adhere to the Posse Comitatus law, we're not going to use the military in the United States